Yesterday, I did a Facebook Live concerning this pattern that I've been seeing. Three or more becomes a pattern, and we've surpassed that, and it's been different schools. And so I've been trying to figure out what is different about this school year as opposed to last school year, because I'm seeing an increase this early in the school year of early releases of my clients, quarantining of my clients, and especially kids under 12. And that is a remarkable shift away from how schools reopened last year in Alabama, first and foremost, because that's what I was looking at today. And in my discussion with a couple board attorneys to try to sit there and ascertain what policies have changed, the consensus was that yes, there's been some drastic departures from how the recommendations with regards to the COVID protocol response was done last school year as opposed to this school year. And what's the big difference? Well, we have emergency use vaccines. And I'm going to say that again, emergency use vaccines. And and they're available, I believe, 16 and up, 12 and up still with the emergency use. All vaccines are still emergency use. There is no FDA approved vaccine on the market. One was approved, but it's not on the market yet. And you sit there and you go, well, it's the Pfizer vaccine. Yes, it's a Pfizer vaccine under the very legally distinct name of Comirnaty. And Comirnaty doesn't exist right now. It has to have its own labeling, has its own packaging, has its own insert. Guys, I did a lot of research about that, and the same day that they approved Comirnaty, they also reauthorized the emergency use of Pfizer BioNTech COVID-19 vaccine. So that's the one with broad liability protections for the pharmaceutical companies. And besides that, if we truly had an FDA-approved vaccine, they could no longer use the emergency use vaccines, because the rules with regards to the FDA's emergency use policies in and of themselves, they can't use experimental or emergency use items if there is a viable alternative available. And supposedly one exists in the form of Comirnaty. But like I said, they're legally distinct. And when something is legally distinct, that means that there's liability for one, no liability for the other. And so therefore, I highly doubt that Comirnaty will be on the market anytime soon, because Pfizer doesn't want to have liability exposure. So I diverge. So when it comes to the big remarkable difference in this school year, it is because we have what we didn't have last year, and that is emergency use vaccines. That's what's the difference. So I'm going to go ahead and switch over. This is the document that the Alabama Department of Public Health has put out with regards to back to school guidance. Okay. And it was sort of recommended, and now from what the board attorney tells me, what the board attorneys have told me, that this is no longer optional. And so this is what I wanted to point out, is that the Alabama Department of Public Health has adopted this guidance and issues these recommendations for schools for safely returning to in-person instruction, but they took it from the CDC guidance. So there's a link you can click on to sit there and compare the two, but they're going to be very similar. All right. So the other one is that schools are required to report suspected and diagnosed COVID-19 cases, just as they are required to report other communicable diseases in the school environment. and they're supposed to isolate and report suspected and diagnosed cases. So individuals who test positive for or are diagnosed must stay home for 10 days following the onset of symptoms or a positive test result, be 24 hours without fever or fever-reducing medications, and experience symptom improvement before returning from isolation. And school principals and nurses are mandatory reporters under the notifiable disease law. Therefore, all suspected and diagnosed COVID-19 cases must be reported to the online report card. All right, so we go further down. Now, people with COVID-19 may experience the following. Look at all those. And, geez, that looks a lot like the flu. That looks a lot like a lot of other things. Very easily confused. If you take some of these by themselves, could be confused with common cold. Let's say some of these could be associated with just a stomach bug, could be associated with the flu, could be associated with allergies, all of those things. So here we go with the close contact exposure. And this is where I wanted to pick up. So school officials should notify individuals who are close contact to a diagnosed COVID-19 case as soon as possible, and to prevent outbreaks in the school. And then I'm going to show you attachment F. But the CDC definition of close contact is someone who is within 6 feet of an infected person. That would be laboratory confirmed or clinically compatible illness. Guys, remember what I just showed you up here? What is a clinically compatible illness? It could be any of these things. Okay? Remember, they're supposed to report suspected and diagnosed COVID-19. Not necessarily diagnosed, meaning laboratory confirmed, but then also you have clinically compatible illness. And so that is also being thrown into all of this. For a cumulative for 15 minutes or more than a 24-hour period, example being 3 individual 5-minute exposures for a total of 15 minutes is sufficient for that to be considered in their contact tracing. An infected person can spread COVID starting from 2 days before they have any symptoms, or for asymptomatic patients 2 days before the positive specimen collection date, meaning when they test positive, until they meet the criteria for discontinuing home isolation, which we read earlier. In K through 12, indoor classroom setting, the close contact definition excludes students who are 3 feet or more, but within 6 feet of an infected student. That would be somebody that was laboratory confirmed or a clinically compatible illness. If, this is important, if it excludes these students, if both students were engaged in the consistent and correct use of well-fitted masks, and, not or, and, so both of them have got to be there, and other K through 12 school prevention strategies such as universal and correct mask use, physical distancing, increased ventilation were in place. Now, I'm going to stop there for a second. Guys, with the states that have sort of left it as optional, do you see where the devil's in the details here? That according to the CDC guidance with which the Department of Health in Alabama adopted, which isn't the governor, it sort of is, it's not. There's sort of an independent rogue agency. I'm going to say rogue agency because they're just sort of doing what they want. Now you can sit there and say, well, they're following CDC guidelines. Well, I think the CDC is compromised. It's a highly politicized. I wish it wasn't, because I wish that I had faith, but I feel the same way about the FBI. Our institutions right now that are there to protect us and provide us with guidance and safety are absolutely corrupt and unreliable. Unless you've somehow been on Mars for the past year and haven't been here over the past year and a half to sit there and have to be exposed to the ever-changing guidance from the CDC and in how to deal with this, which has caused nothing but mass confusion. It has stoked fear, panic porn, you name it. And so it just doesn't help. And so when it comes to the states, for example, mostly red states and mostly in the South that have sort of left it up to the schools, with regards to, or left it up to the individual. Let's say that, left it up to the individual on whether or not they want to mask, whether they want their children to wear masks, which I don't think is a bad policy. All right, I think universal masking, forced masking, mandated masking, I don't think is the right way to go. Now, why is that? Because I have a lot of clients that can't wear masks, guys. My child can't wear a mask. That doesn't mean that I don't want you to wear one. That doesn't mean that you can't do what you want to do. But to sit there and say that everybody has to do it or else it doesn't work is absolutely ridiculous. It's circular reasoning. That is just not the case. If your mask protects you, then the mask protects you, right? But if the majority of people, like-minded people like you, want to wear one, great, do it. But to sit there and say that everybody has to do it and then sit there and stigmatize or target those who can't, I got a problem with that. And then, we're going to tussle because, I've got clients that can't wear them. Just as much as I fight for those who need to wear them, but they need a reasonableness standard where that can be applied, okay? There's a reasonableness standard in this world. I mean, it might not look like it right now, okay? But I just find this to be a highly politicized set of requirements or recommendations, that filter down from the CDC and then adopted by the Alabama Department of Public Health. And you sit there and you say, well, how is that? Well, to sit there and sidestep these states and these governors that are saying that schools cannot mandate masks. Alabama isn't one of those. The governor sort of left it up to the states, to the individual schools to determine. But like Texas and Florida, they can't do that. And then, of course, there's some that are acting in defiance of the governor's orders. But here you go. Here's your contact tracing requirements, and that's what we're seeing is that close contact definition excludes each student, which means that they don't have to report these things. The close contact definition excludes the ones that have been wearing masks like good little kids, correct and well fitted, mind you, and then the prevention strategies. So both of them have to be done together. So let's go down to the rest of it, which is mind-blowing. Provide recommendations and information to staff who are close contacts and to parents and guardians. Asymptomatic vaccinated close contacts do not need to be sent home, but should monitor for symptoms. Asymptomatic close contacts who have tested positive for and recovered from COVID in the prior 3 months, natural immunity, do not need to be sent home unless they develop symptoms. Asymptomatic close contacts who meet the K-12 indoor classroom student exclusion notated in the previous section. And guys, this one, point number 3, the asymptomatic close contact to meet the classroom exclusion, this one, this one, that is going to be your disability ADA special education 504. Unvaccinated individuals Unvaccinated individuals who are identified as a close contact and do not meet the K-12 indoor classroom student criteria above must be sent home. School officials should share attachment F with staff. And so much of this stuff is arbitrary, guys, because if you remember, the K-12 indoor classroom student requirement is also saying that it needs to be well fitted and properly and consistently worn. Let's say your special education child can't, it's not well fitted. Well, it's very arbitrary and sort of up to the beholder because you're not there. And so if they sit there and define it in a way that they want to through their perception or their observation, then your child's being sent home. And especially any child under 12 or any child under 16, depending on their vaccination status, they would be those kids that are being sent home. Okay, but those who have received vaccines, you see where the incentive lies, which I think is discriminatory, because the science absolutely does not back up this nonsense recommendation, because there are breakthrough infections In fact, there's science out there that shows that vaccinated individuals can carry a viral load 27 times higher than the unvaccinated. So, whether they're asymptomatic or they're not, the fact that we just sort of get to gloss over it and ignore that, I think is also ridiculous. That's not true science. If we want to be sort of nitty gritty, okay? Um, Now, here we go with the special circumstances to consider regarding mitigation and prevention. Federal and state disability law may require an individualized approach for working with children and youth with disabilities consistent with the child's individualized family service plan, individualized education plan, their IEP, Section 504. An administrator should consider adaptations and alternatives to prevention strategies when serving people with disabilities while maintaining efforts to protect all children and staff from COVID-19. So this is an individualized approach. This is the most important aspect of what it is that I wanted to point out to you. Okay, I will have a link to this for you in the comment section or in the body itself of this post, so that you can read it and you can follow it. I highlighted it. It was not naturally highlighted, so I highlighted these sections so it's easier to catch your eye as you're reviewing it. But guys, if I have clients that are in a revolving cycle of being dismissed because of these kind of things, they're supposed to be alternative mitigation and prevention strategies. That includes kids that cannot wear masks, those that are protected under the ADA. Guys, those laws never went away. Those protections never went away. Here is our example. It never went away. And so therefore, there must be, the law may require, it does require individualized approach in these situations. So there you have it. There you go. Equipping you with the knowledge that you need in order to make the decisions for your family in these difficult times. And this is not to impugn anybody in their position, okay? Because I have clients that legitimately, on each side of this argument, require in-person learning and require protection. We can think outside the box. We are an intelligent people, and we have a lot of resources. And in fact, they devoted a heck of a lot of resources in order to give to schools this past summer. Not this summer, in the summer of 2020. And this, I'm talking about billions distributed for COVID-19 relief and putting their school in a situation to be able to respond to these things. Additional funding was also provided during the Biden administration. But the first round under the Trump administration happened during, May of 2020? So to sit there and say that we can't figure this out and it's got to be done one way and one size fits all is nonsense. And those of you who believe that, please stop. It's dangerous. It's divisive. And the science is not backing that up. There are breakthrough infections. Vaccinated people are getting COVID, and they are spreading COVID. So to sit there and have this out there to where we are differentiating and discriminating against somebody due to vaccination status, which is exactly what this is doing, and then incentivizing those with vaccines, because it says that later in the thing. It's just clever language later on to where, let's see. Trying to find it. Well, you guys can read it, okay? Review this. I'd like your input. I'd like to have a discussion about it and see what your thoughts are. Be informed. Say something to your school board. Have a meeting with your principal if necessary. If your child is one at risk and you're afraid that they could be caught in this cycle of removals from their school environment because they were not afforded an individualized review and approach on how to deal with this if it were to happen. And I think it's going to escalate. But if you're in another state other than Alabama, guys, this is based upon the CDC guidelines. So this is applying everywhere. So if you're seeing this cycle in other states, let's say in Texas or Florida, well, this is why. This is sort of an in run around your governors. Okay, clever but political.